Chief, thank you very much, and thank each of you for your testimony here today and for the opportunity to now engage in a round of questions. I'm going to defer my questions to Senator Mark Wayne Mullen from Oklahoma. You may begin.
Thank you so much. Chief Barnes, how was the Shawnee Tribe recognized?
We had a separation from the Cherokee Nation in the year 2000. It was we were under the authority of Cherokee Nation as citizens, and that was via
how was you recognized? Which path did you choose for recognition?
We had a path of recognition to separate us from the Cherokee Nation, and that was established by an act of Congress.
Act of Congress. How many paths of recognition is there for a tribe to go through?
You have the act of Congress. You have an OFA process.
And you chose to go through Congress because?
We had an OFA review. It came down to a document that was signed by Fred Half Moon in the 60s. And if our continuity of government, it hinged upon that government had been continuous. So as part of our separation, our separation was not identifying us as a tribe. It was separating our tribe from the Cherokee Nation. We relate to the Oklahoma.
But you asked for recognition through Congress, right?
That was how our process happened. Yes, sir.
Do you believe the Lumbees are native?
It's not what I believe, sir. I have no belief in the matter. My matter is in the OFA. I believe in the process. I believe that the OFA process exists whenever the.
But isn't there two ways? Evidence. Isn't there two ways to be recognized? Right? Congress has authority to recognize. Correct?
I agree. Yes.
Okay. Chief Hicks, do you believe the Lumbees are native?
I think there is potentially native descent. It doesn't make them a tribe.
Why did North Carolina recognize them then in 1885?
North Carolina, to my understanding, has different standards for the recognition. I'm not sure today that the Lumbee could pass the standards that have been put in place by the state of North Carolina.
Did the federal government recognize them in 1956?
To my understanding, and my conclusion of the 1956 acts is simply recognize the name of those who self-proclaimed Indian in a 5-county area in eastern North Carolina.
Did the federal government recognize them as a tribe in 1956? That was my question.
I believe so. Not in my conclusion.
So, do you believe there's two paths for recognition, and Congress has a right to have to recognize them?
I do agree with that, yes.
Congress now, you raised up concerns that it was the cost. Mm-hmm. Is that correct?
Yeah, that was part of my testimony.
So if it's the cost, should the federal government not recognize any more tribes coming in?
That wasn't the point of the cost. I think it needs to be
considered. Well, it is, because when you're raising cost, you're raising the cost that it would be to recognize the Lumbee Tribe. Because I do believe they're native. I've been accused of not being native. And I always laugh, and I said, I can't control who my ancestors loved, but I still live on the same allotment land where my family stopped walking because I am Cherokee, and I'm proud to be Cherokee, and my family's been there since 1840, but yet I've been accused because I may not look full native. And I have a problem when someone starts saying that. I have to actually take it a little personal. And Chief, there's actually a split between Cherokee Nation and the Eastern Band. Would you agree?
What is your question?
There was a split between Cherokee Nation and the Eastern Band. Cherokee Nation, my ancestors, we walked, and the Eastern Band stayed back. Correct?
That is correct.
But you were fairly recognized. Shouldn't you be recognized underneath Cherokee Nation at that point?
I mean, if you look
because we're all descendants, Cherokee Nation.
Do I get to respond?
Sure.
So if you look at, the history of recognition, obviously the OFA was not established till 1978. Mm-hmm. The government, stopped doing treaties in 1871. The Cherokees, without question, was an established government. And, if you look at,
I know the history of the recognition. I get that. My point is that you're saying that the Lumbees, that they are or aren't descendants of the Eastern Band or Cherokee Nation, really, because Cherokee is Cherokee, so it'd be your descendants of Cherokee Nation, in my opinion. But you're saying that they should be recognized because there should be part of you, but you should be part of Cherokee Nation. It doesn't make any sense to me because you're complaining about cost, you're complaining about their path of recognition, and you're complaining that they may or may not be native because they don't have the heritage behind it. And I'm saying, well, they were recognized in 1885. The cost shouldn't matter, because if that's the cost, then we shouldn't allow any more tribes to come in, and we should stop enrollment, because we have a federal obligation as Congress, a treaty obligation, a constitutional obligation to have oversight of the tribes. We have the authority to be able to recognize tribes without question. And it just seems like this argument continues to go through because of my opinion of the territory dispute. That's my opinion. Because you can't look over there and say they're not native. I mean, turn around and look, and you're telling me they're not native?
I've seen the crowd.
Okay, and you're saying that that's not native faces?
That's not for me to determine. That's for the OFA
but
process.
we are determining it.
That's for
And
the
that's why I
OFA
support
process.
recognizing them. Because my fight up here has been always for Native Americans. I was shocked when I got up here that when I first got to Congress, it was just Thom and I were the only natives in Congress at the time. And I'm in the Senate, and I'm the only Native American in the Senate now. And I hate when we fight among ourselves, because we should all be in the same boat, rowing the same direction. If we're Native, then we were wronged a long time ago by the United States. And we've been fighting for recognition for a long time. And when we have in-house fighting, it causes Congress sometimes to have an impasse. And I think you know that. This happens all the time. A lot of times it has to do with gaming. And all we're saying is the Lumbees have a right to be recognized just like you have the right to be recognized.
And we don't disagree with that as long as it's through the OFA process.
But if they have two options, why is it your opinion that they can't choose the one to go through Congress?
Because that's why this department is established. It's for evidence and
But there's clearly two paths. And I appreciate the paths they took. Chair, thank you for the extra time. Thank you for allowing me to go first. For the record, that's already been established by the Interior, they do support this process, and they support the Lumbees of becoming recognized. And I, too, also support the Lumbees of being recognized.
Thank you, Senator Mullen. Senator Schatz.
Thank you, Chair, and thank you to the testifiers. Just a couple of thoughts before I ask Professor Locklear a couple of questions. You know, I think it's really important to assume good faith here, and what I've heard is a kind of concerning series of accusations about bad faith. And I'm trying to go back to 1888 and imagine that the Lumbee people, whatever they were calling themselves, whatever language they were using at the time, says, you know what, why don't we pretend we're a tribe and petition the federal government? If this is a conspiracy, it is long-standing, kind of odd, counterintuitive conspiracy. The more likely explanation is what the Department of Interior said about 90 years ago, 100 years ago, when they explicitly said, we're not going to recognize this tribe because the census is too large, because we can't afford to absorb the cost of delivering services. And I think that is, by the way, I think that's a valid concern for congressional appropriators, right? If we are to recognize Lumbee, the rolls just increased. The total number of people in Indian country went up, which means IHS, BIE, BIA, and all of those services are going to have to increase by the percentage that the rolls increase. And so that's a real issue. It's just not a reason not to grant recognition. And the reason I'm animated about this is that I don't know whether Native Hawaiians are ever going to come back to this Congress and seek recognition. But I remember, I was not here, but I remember when Danny Akaka, chairman of this committee, tried to get recognition. And the arguments were, do you know how many people that is? Do you know how much that's going to cost? And then, well, they're not Indians. And so I don't take it as personally as Senator Mullen, but I do take it personally. And I'll just say one other thing. You can go through the administrative process or you can not. But the Constitution vests not just the Congress, but this committee with this authority. So it may be that you think we should have gone, or these folks should have gone through the administrative process. Fair enough. But that is not a meaningful obstacle to consideration of Lumbee recognition. So, Professor Locklear, I just want to give you an opportunity to, again, respectfully, rebut some of the claims made by the opponents of this legislation. Three things. Lumbee has used different names for themselves, that they have no language, and that they do not descend from a historic tribe. Could you address those three assertions?
With pleasure, Senator, and thank you for the question. First of all, with regard to the name and why it came about, the Lumbee children in 1884 were not able to go to school. Our children could not read or write. We were not allowed to attend either white or African American schools. In 1885, our leaders sought recognition from the state of North Carolina for the purpose of establishing schools for our children. We prevailed with the assistance of a Mr. McMillan in the House, who deemed himself to be an amateur historian at the time. Mr. McMillan chose the name Croatan for our people. But in his legislation, he did important things. He established a government-to-government relationship. He allowed the creation of an independent school system run by the tribe, limited to tribal children, and taught by members of the tribe. To my knowledge, no other tribe in the United States can claim that history. So beginning in 1885, we controlled our own school system until the 1970s, when a federal district court ruled that the state of North Carolina must desegregate its school system. We thought we were exempt from that because, after all, we are an Indian tribe. But the judge told our parents, you must bus your children because this is a racial classification because you are not federally recognized.
Okay, and to the language?
Yes. There is no requirement in either Supreme Court or other federal court authority or the acknowledgement regulations that our opponents so warmly embrace that require the presence of a language.
Yeah, I mean, a lot of these things, it seems to me, are historical facts, and they happened because of United States federal government policy. We lost language because of federal policy. People lost a land base because United States federal government policy. And then it is not surprising that the Department of Interior repeatedly rejected the claims of the Lumbee people, because the Department of Interior, I mean, the idea that we should accept the precedent of the Department of Interior from generations back, when I think there is unanimous bipartisan agreement that the whole purpose of this committee is to reverse all of those policies, termination and assimilation. And to use that as a proof point against recognition, I find to be not compelling. Now, there are criteria that we're to use to determine whether or not to recognize Lumbee. But the idea that, well, DOI didn't do it in 1930, or they don't have their own language, well, there are, and frankly, we work a fair amount on language revitalization, and there are a lot of tribes that have very few native speakers left or none. And so none of this is disqualifying because, frankly, many, many Native people across the country have experienced that. I did not expect to get so exercised, but I appreciate your testimony.
If I may I offer
with
one
the chair's
final,
permission.
Go ahead.
Thank you. One final fact on the language point that I think is important. Vine Deloria, when he testified in 1988, made note of the fact that he had not only personal knowledge of the Lumbee tribe, but also family knowledge of the Lumbee tribe, because his aunt, Deloria, had gone down to the community, who was a noted linguist, for the purpose of studying the remnants that remained of tribal languages. And she made note in 1940 that those remnants existed, and her purpose was to establish a dictionary. She did not complete that work because she was not able to get funding. They were not interested in our community to do so.
Thank you, Vice Chairman. Chief Hicks, I want to direct this to you because you have made very clear that on behalf of the Eastern Band, that you think that the Lumbee should go through the Office of Federal Acknowledgement, through the administrative process, rather than come through recognition through Congress. Maybe it is accurate that the administrative route is perhaps more costly, harder to do, subjective. Maybe we need to look at that in terms of whether greater oversight is needed there. But as Senator Mullen has indicated, there are two tracks, two routes that you can proceed for recognition. I almost find it curious that federal recognition is ultimately about a political relationship between a sovereign tribe and a federal government. So it just seems somewhat curious that we actually set up a process where that decision can be delegated entirely to an administrative state. But I'm not going to ask you to resolve that question for me. What I want to turn to is your written testimony. You claim that the Lumbee situation is uniquely beyond Congress's capacity to understand and evaluate. Can you explain why you feel it is unique in some way, separate from other tribes that have gained recognition through Congress? Because again, we have this process. It has been repeatedly exercised in terms of its constitutional authority to gain tribes. So if you can cite to what you feel are some of the unique aspects as to why Congress should not be the avenue here.
Thank you, Chair Lady, for that question. I think, if you look at the gaps that have been clearly identified by historians, by researchers, related to the history, these are aspects that I feel need expertise. They need genealogists. They need historians that do this on a daily basis. And, unfortunately, congressional staff don't always have that expertise to really dig into, the subject matter documents or the church records or, court records, things of that nature to really relate back to what is necessary as we feel to prove what you're saying is substantiation. And so, again, I think as you look at, that setup and that structure, OFA is better suited to make these determinations.
How do you respond then to Ms. Locklear's statement that she made early on that given the number of congressional hearings here in the Senate, in the House, that this issue of federal recognition that Lumbee is seeking has not established quite a voluminous congressional record with which to be able to turn to?
I truly believe that, if the Lumbee group would go through the OFA process, they would get the answer that they're looking for, wherever that answer falls. And, as you think about, this issue is well over a century old, and it continues to come back to the same conclusion. There's too many gaps in the genealogies. There's too many gaps in the history. There's no treaty relationships. Lumbee does not have a sister tribe in Oklahoma. There's so many things here that need to be evaluated. That's the importance of why it needs to go through the OFA process.
So, Ms. Locklear, let me turn to you. You have testified that congressional recognition is needed to correct what you have termed an injustice. Beyond that, you've got some practical differences between recognition through Congress and recognition from the federal acknowledgement process. You've got the ability to take land into trust, particularly in the post-Carcieri world here. Can you speak to some of these practical differences between the legislative and administrative recognition, and whether you think those are drivers for this legislation?
Absolutely, they are. Let me summarize with just a few points. First of all, I think it's important to put this controversy in some general history. As the Special Indian Agent reported in 1915 in the O.M. McPherson report, there is a history of 300 years of hostility between the Cherokees to the west and the ancestors of the Lumbee people, including the Shira, the Hatteras, and related Siouan-speaking people. And we just have, I think it's important to understand that context. As to the other issues, so as a practical matter, because of that, only Congress can resolve it forever. We have been at this for more than 100 years now, and I guarantee you that were the tribe to go through the acknowledgement process and succeed, as I am confident we would, there would be a lawsuit filed by the Eastern Band of Cherokee to try to set that administrative agency decision aside. That would not resolve it. There's only one way to finally resolve it, and that's through a conclusive act of Congress that extends full benefits and services. As you also implied, there is a problem with the Carcieri issue, which relates to eligibility of newly recognized tribes to receive land in a trust and thereby be treated like all other federally recognized tribes. Because of that 2009 Supreme Court decision that we call Carcieri, the only way to resolve the eligibility of the Lumbee for that process is through an act of Congress. Only Congress can clearly indicate that it considers the 1934 date to be insignificant, and whatever may arise out of the Carcieri decision, notwithstanding those terms, the tribe is nonetheless eligible for the land in the trust process. And finally, if there is going to be a special addressing of the cost factor, we don't think it's necessary, which I'm happy to expand on, but only Congress can do that as well. Congress is the one who appropriates the money, and if there needs to be more money for the Lumbee services, Congress can do that. We think the existing processes for appropriations will protect the presently recognized tribes, both in BIA and IHS processes, provide that only through the appropriation of additional funding that pay for those services will the Lumbee members receive those services at the end of the day. So federally recognized tribes now are protected. That being the case, if they believe there should be an increase in federal funding for the IHS and the BIA, again, that's a political decision to be made by the Congress. So we think for all of those factors, one final one, if I may. Only one other time in history has the Congress put an Indian tribe in the same position that it put the Lumbee tribe in 1956. And that was with the Islero del Sur Pueblo of Texas. Congress passed a statute in 1968 for that tribe, which was at the time federally recognized, which basically said, we transfer any responsibility we have for this tribe to the state of Texas, and we're going to impose termination language upon the tribe. And in the legislative history on that act in the Senate, it specifically says that 1968 act, which then referred to the natives as Tiwas of Texas, was modeled upon the 1956 Lumbee Act, the only other time Congress has done that. And Congress fixed that problem in 1987 by passing legislation to recognize fully the Islero del Sur Pueblo of Texas. Now, if Congress does the same for us, there are no other tribes in that position, and that's what makes it fair and just, as well as the only appropriate and fully dispositive way to finally and conclusively resolve these issues.